evening, everybody, and a warm welcome to all of you. It's a great pleasure to see such a full house. A warm welcome to this, the first lecture of the new year in the Madness and Mental Health series brought to you by the Royal Institute of Philosophy. So with that out of the way, it's a great pleasure to have with us this evening our speaker, Dr. Claire Hogg. It's a personal pleasure for me because at the beginning of her distinguished and growing academic CV come 3 years studying philosophy at Keble College in Oxford, which is my own college. So after that, she did the BPhil in Oxford. She did an MA in medical law, medical ethics and law at King's. Then she went on to a fully funded PhD in law at King's. I may be missing out some of your many qualifications, forgive me if so. And then on to the ERC, as a postdoc, ERC-funded project, The Roots of Responsibility. And she's just deservedly got her first permanent job. In fact, I'm told that the job begins on Monday. So we're especially grateful to you, Claire, when you're thinking about moving house and teaching people new stuff, that you've given up your Thursday evening to lecture to us. And your topic is mental disorder and the criminal law. Claire, over to you.
Thank you very much. Okay, so thank you all very much for coming. I'm a researcher basically with a background in, as Edward said, philosophy and law. With respect to law, I'm particularly interested in criminal law and mental health law and kind of at the intersection of the two. So when I was studying philosophy, I was especially interested in the relationship between a mental disorder and specifically compulsive disorder actually at the time, and models of moral responsibility. And so when I moved into studying law, I saw that a lot of the same questions apply in the context of legal insanity and mental condition defenses generally in the law. So my research now is focused on two questions. Firstly, how do we understand the relationship between culpability and mental disorder? So more specifically, how do we understand and account for the impact that a mental disorder might have on factors that are relevant to culpability questions like about responsibility, blameworthiness, agency, and so on? And secondly, where a defendant's mental disorder might potentially play that kind of exculpatory role, how can we fairly and accurately account for that within the culpability determinations that the criminal law makes? So in other words, the question of legal insanity, as I'm kind of framing it, asks us to think about the nature and scope of the relevance that mental disorder can have to culpability, and the way in which that relevance ought or ought not to be reflected in the criminal law. Okay, so before I go any further, I just wanted to say something to clarify, because it's sometimes difficult when you're in looking at mental disorder in the context of criminal law, when you're kind of in between the criminal and the mental health law, because a lot of people working in the mental health law field are very concerned about the use of extremely restrictive civil legal measures on people with mental illness. And one of the worries is that there is this close association in the public eye between violence or criminal activity and mental illness. And that makes my position a little tricky sometimes, because I'm kind of, you've got people on the mental health law side trying to get people to stop making this association all the time. And I'm kind of pointing to the tiny number of cases where actually someone has broken the law or has done something violent in a way that may be in some respects attributable to mental illness. So I just kind of wanted to kind of premise all of this by saying that the vast, vast, vast majority of people with mental illness, even the most severe mental illness, including psychosis, will never commit any crimes, do anything violent, hurt anyone. These are very tiny, restricted number of cases. And the reason that I focus on them is because I think that no matter how few there might be, it's still really important to get the culpability question right in these cases. These people still deserve, if they weren't fully culpable, to have that assessed accurately and fairly. So it's important to do this, but it's also important, I think, at the start to put it in a broader context, that these are small numbers of cases. Okay, with that said, let's kind of move on. Okay, so I wanted to start with a scenario, right? It's a made-up scenario. It's kind of based on or influenced by cases that I've seen, but it's not based on any specific one case, and it's completely made up. So Ms. X is our kind of case study. She suffers from a psychotic disorder. She's going through a particularly serious episode, and she develops an obsessive delusion that her neighbor, who is a new mother, is mistreating her baby, that the baby's being abused and is in danger. She tries to call social services. She tries to call the police. At first, they investigate, but it's completely groundless. There's nothing going on that's wrong. The baby's absolutely fine. But she doesn't believe them. She keeps calling. And she eventually comes to think that maybe the police and social services are colluding to hurt this baby as well. She becomes more and more distraught at the idea that the child is going to be harmed. And eventually she gets to the point where she breaks into her neighbor's house and takes the child. She removes him to what she thinks is a safe location. And the next day the police find her hiding in a nearby hostel with the infant, who is unharmed. She's taking good care of him. Okay, so this is our kind of example scenario. So I have a few questions that we might want to think about here. The first is, do we think that someone like Mrs. X or Miss X should be regarded as culpable for her action? Should she be seen as morally responsible here, fully morally responsible? And should she be blamed? And if we don't think that she's fully culpable, what is the source or the nature of that non-culpability? What is the source of the exculpation here? And thirdly, moving to the kind of legal area, how should the law be constructed to reflect that non-culpability within its determinations? So I'm going to take us through some different analyses with reference to the law. So it's kind of different kind of moral analysis, and then I'm going to sort of also show how it's reflected in different legal models that are used in different jurisdictions. Okay, so the first one, let's start with the idea that Miss X may not have a defense at all. So we might say, well, Miss X has no defense. You know, maybe her psychosis could be taken into account as a mitigating factor when we get to the point of sentencing. You know, maybe we don't send her to prison, right? But that doesn't mean it has bearing on the question of her criminal culpability. She's guilty of a crime, but we might think maybe prison isn't, you know, a great outcome for her here. So it could be mitigating at the point of sentencing, but it doesn't affect culpability. This seems quite a hard take, I think. Maybe some of you disagree. I think it seems quite hard. But how could you argue it if you were going to make this kind of case? Well, I suppose the first thing we could observe is that Mrs. X knows what she's doing. She's not in a state of confusion such that she has no idea what's happening around her. She clearly has enough kind of wherewithal to be able to break into the house, take the baby, take it to a safe location, and care for it reasonably competently. So she's clearly operating with some degree of kind of practical competence and situational awareness here. She knows that she's abducting a child from its parents, right? She doesn't think she's doing something else. She doesn't think the baby is hers, or that she's doing something innocuous or something lawful. She knows what she's doing. And it's likely, I would say, that she probably knows that this isn't something she should be doing, strictly speaking. She probably knows that it's unlawful or prohibited, which is demonstrated in the scenario I put forward by the fact that she is conflicted about it. She tries to go through legal avenues first and then turns to this action as a last resort. So if we wanted to kind of say, well, there's no defense here, what we might say is, well, Miss X knows what she's doing, and she knows that it's something she's not legally permitted to do. Perhaps she thinks it's the right thing to do. But believing you're doing the right thing is not generally a legal defense in itself. So it's not necessarily clear why it would suddenly become one when the belief is delusional rather than simply mistaken. Now, this might seem a really harsh analysis of Miss X. I don't necessarily disagree, but this is actually pretty much what we have in England and Wales in terms of the insanity defense. So this is the insanity defense as it applies in England and Wales, and the rule is that a defendant, due to a defective reason caused by a disease of the mind, either did not know what they were doing or did not know that what they were doing was wrong. And the way that we've interpreted did not know what they were doing was wrong is in strictly legal terms. So you have to have not known that what you were doing was illegal. So this insanity defense originates from Daniel McNaughton's case, which was from 1843. So we've had these rules since 1843, and under them, I think Miss X probably would not have a defense. So the case of Windle is the one which specified that wrong has to be interpreted as illegal. And as we'll see, a lot of jurisdictions apply McNaughton. Very few of them apply it in this very restrictive way that we do here. So I think under the law of England and Wales, it seems like this is probably going to be the outcome for Mrs. X. She is not going to have a defense because she knew what she was doing, and she knew that it was illegal. And we can tell that she knew that it was illegal because she tried to go through legal avenues first and then gave up on them. Okay, so that's a bad outcome for poor Mrs. X. But I think that we might feel intuitively, someone like her deserves some kind of defense. This doesn't seem fair, I feel. Maybe you agree. It seems like there needs to be some recognition that her mental illness had an impact on her actions, possibly in a way that might reduce or remove her culpability for them. So let's say we do want to make that claim. We think that the law in England and Wales is wrong to not provide her with a defense, to not exculpate her. Well, we need to think about why we do want to exculpate her. What is the nature of that exculpation? So I want to kind of look at a few different options and see how they might play out as legal tests. And we're going to be moving away from the McNaughton rules now, but we'll come back to them later. Okay, So the first, or I suppose the second take that I want us to look at is the idea of appealing to causation. So the idea here is that Mrs. X may not be culpable because her act was caused by her mental illness. So but for the experience of psychosis, she would not have acted as she did. If it wasn't for that psychosis, this is not something she would ever have done. This kind of an analysis is applied in the law in something called the Durham or the product test, which for a short period of time was applied in the USA. The idea was that a person will have a mental condition defense, they will have an insanity defense if their action was the product of a mental illness. So specifically, I think New Hampshire applied it since the 1800s. Then in the 50s, it was articulated in a federal case called Durham v. US, 1954. And that led briefly to widespread popularity. In the long term, though, it was felt to be too broad. I think particularly they were worried about it applying to people with substance abuse problems. And they felt that they just didn't want it to apply in those cases, and it just was too wide. So it was ultimately abandoned by the federal court in 1972 and currently applies only in the state of New Hampshire, which is, and even in New Hampshire, it's been narrowed to only the most serious cases of mental disorder. So this idea of causation being the key, it's about whether it was caused by mental illness, is one possible analysis and one that's been applied in some legal tests, although a very kind of narrowly applicable one. Okay, so thinking about causation from the kind of philosophical side, though, I suppose, why would causation be exculpatory in this way? I think that there are reasons to kind of question this kind of analysis. It seems like the fact that an act is caused does not necessarily mean by itself that we aren't responsible for it or that we can't be blamed by it. Most of the things we do are the result of some kind of causal nexus. Every act is subject to some but-for conditions. And that in itself is not generally regarded as negating culpability outside of maybe the hardest line determinists. So saying that Mrs. X would not have taken the baby if not for her mental illness doesn't seem enough by itself to lead to the conclusion that she's not culpable. If we want to say that this is a special kind of but-for cause that removes culpability, I think we have to add some extra steps or kind of beef up the claim a little bit. So one way we could potentially beef up the claim is by appealing to compulsion. We might say Mrs. X is not culpable because her act was compelled by her mental illness. Given her experience of psychosis, she could not have done other than she did. So we're kind of beefing up this causation claim a bit here by saying it's not just that it caused her action in the sense of being a but-for causal factor. It actually compelled her to act. It actually made it such that she lacked the ability or the freedom to do otherwise. So this, in terms of the legal approach, this kind of idea is reflected in some insanity models around the world. So in England and Wales, we apply a self-control, irresistible impulse prong with respect to diminished responsibility. So diminished responsibility is, unlike insanity, it's a partial defense. What that means is that it only applies in cases of murder, and it functions to reduce someone's charge from murder to voluntary manslaughter, which doesn't carry a mandatory life sentence, whereas murder does. So it's one of a few partial defenses you could introduce if you've been accused of murder to say it's not quite murder, it's still bad, and you're still probably going to go to prison, but not for life. It can kind of reduce it a little bit. This is in contrast to insanity, which is a complete defense and applies to every charge. You can raise it for absolutely anything. But diminished responsibility, unlike our McNaughton insanity rules, includes a condition that a person may be able to plead diminished responsibility if their ability to exercise self-control was substantially impaired by a mental condition. And other jurisdictions that apply, in the way they apply their McNaughton test, add that kind of prong to their McNaughton rules as well. So some jurisdictions in the USA, for example, they have the ordinary McNaughton rules as I set them out, although they may interpret them slightly differently. But they also add this extra prong, specifying that if you were under an irresistible impulse to act as you did, then you may also have an insanity defense. Sorry, an irresistible impulse caused by your mental condition. There has to be a causal link. And the first appearance of this test was here in Commonwealth v. Rogers in 1844, where Chief Justice Shaw said, "If then it is proved to the satisfaction of the jury that the mind of the accused was in a diseased and unsound state, the question will be whether the disease existed to so high a degree that for the time being it overwhelmed the reason, conscience, and judgment, and whether the prisoner acted from an irresistible and incontrollable impulse. If so, then it wasn't the act of a voluntary agent, but an involuntary act of the body without the concurrence of a mind directing it." It's an interesting way of kind of understanding it. He's basically saying it wasn't your act in a way. It was just your body kind of acting without your input. Okay, so I think there may be cases where, moving back to kind of Mrs. X's case, there may well be cases where appealing to this kind of compulsion is a very persuasive move. I'm not sure that Mrs. X is one of them, because it doesn't seem on the facts given that she is irresistibly compelled to take the baby, right? It seems rather like taking the baby is a choice she's making in response to the beliefs that she has, specifically that the baby is in danger, and the desires that she has, specifically that she doesn't want the baby to come to harm. At most, I think what we might want to say is that it seems like she could not reasonably have done otherwise than she did, given her understanding of the situation. But that's quite different from saying she couldn't have done otherwise in the sense that Chief Justice Shaw is setting out here, where it's just an involuntary act of the body, right? You might say, well, what could you expect her to do? This seems like the only good option that she has with the beliefs that she's got. That's not quite the same as what he's getting at here with respect to the irresistible impulse, the actual compulsion. And this idea of what she could reasonably have done or reasonably expected to do is one we're going to return to, so kind of hold on to that thought, but we'll come back to it. Okay, so I'm not sure, I mean, there may well be cases where this kind of analysis works. I think Mrs. X is probably not a good example of it. If we want to exculpate her, we might have to try a different analysis. Okay, so the next analysis we're going to try is this one, the real self analysis. And it's sort of still connected to the causation idea. So like, why does it matter that it was caused by mental illness? Well, one reason it might matter is that it illustrates that this was not an action that proceeded from her real self. We might say Miss X is not culpable because this act was not reflective of who she really is. If she hadn't been experiencing that psychosis, Mrs. X wouldn't ordinarily have acted this way. So kind of beefing up the but-for claim in a way. So we could say this but-for condition that we talked about matters insofar as it indicates that the act is not one that can be attributed to Mrs. X's real self. She is not someone who would ever have done this kind of thing absent the effect of her illness at the time. Okay, so suppose that Mrs. X was to, she's recovered, she goes to apologize to her neighbor. If the neighbor's a very kind person, you might imagine the neighbor saying something like, well, I don't hold you responsible because I know it wasn't really you. It feels like that's a plausible response to someone who's kind of contrite after a period like this. And so this fits into a philosophical tradition of real self accounts of freedom and responsibility. And this is something that's particularly associated with philosophers Harry G. Frankfurt and Gary Watson, both of whom took the view that an action is only truly free and therefore responsible if what they call an action's first and second order desires are in alignment. So without getting into kind of the weeds of the different versions of this account, the essential idea is that in order for an agent's acting to be free, it's not enough that they want or desire to X. Xing has to, in some respect, present itself to them as something that is desirable or valuable. And I think, going back to my original focus when I was a philosopher, the cases where this kind of analysis works best are ones where it's a case of compulsion. Someone is acting in a way that is, to use, I think, what is an old-fashioned psychiatric term, kind of ego-dystonic, meaning that it doesn't fit within their nexus of desires, values, beliefs, or self-conception. And yet the compulsion is there, right? They really want to do the thing. It doesn't present itself to them as something that's useful or valuable or helpful to do. It doesn't fit with anything they're trying to achieve, but there's still this irresistible compulsion to do it. In those kinds of cases, I think this real self model can help us to explain why we might say there's no freedom there. But again, I think you can perhaps see that this is a tricky case to make for Mrs. X again, right? At least on this kind of Frankfurtian or Watsonian analysis. Because her act does present itself to her as desirable. Now, you could maybe say, well, it only seems desirable because of her illness. But if that's true, it's only true because of the presence of a false or delusional belief, not because her disorder has impacted her with respect to the kinds of things she values and cares about. She cares about the well-being of children and this baby in particular. And I think the difficulty with applying this kind of case to Mrs. X, applying this kind of analysis, to Mrs. X, is that when you look at her motivations for acting here, it seems as though it really might well represent the kind of person she is, right? She's someone who cares about babies and their safety and doesn't want them to be hurt. And she's someone who is willing to put herself potentially at risk, potentially at the risk of legal sanction, to keep them safe. Maybe that does reflect very well the kind of person that Mrs. X is. And while it's true in a sense that she wouldn't have done this if it wasn't for her illness, that's only because she wouldn't have had the motivating belief, not because this action does not reflect her in some kind of important way. Okay, so I think, again, while the real self model may work in some cases, Mrs. X is, again, going to be a tricky one, which is why I'm using her, because I think she's interesting. Okay, here's a big one. So one really popular argument for these kind of cases is that we need to appeal to the idea of capacity here. So the claim would be, at the time of the act, Ms. X lacked certain capacities necessary to act with criminal responsibility. As such, she is exempted from culpability, just as she would be if she committed the act while she was, for example, under the age of 10, which is the age of criminal culpability in this country. So this is a very popular analysis among some legal theorists. And the idea is that the way that we should understand legal insanity is as a defense of exemption that essentially applies on the grounds that certain capacities are absent and that those capacities are necessary for a person to act in a way that attracts criminal responsibility. So if you don't have those capacities, we don't need to kind of ask detailed questions about why you acted and how you acted and what you thought was going on and so on and so forth. We just say you are not the sort of person to whom the criminal law applies. And the key thing here is that it's not just that the person acted non-culpably, but that the person, due to the impact of their mental condition, was not capable of acting culpably at the relevant time. They didn't just happen to act non-culpably on the facts. They were not capable of being culpable, so to speak. So on this kind of analysis, it really doesn't matter what they did or how they did it, in a sense, since nothing they did while lacking those relevant capabilities could attract criminal culpability. And this is why the parallel is often drawn to childhood, which typically exempts in a similar way. If someone is under the age of 10, there's no way they can carry out an act that's going to attract criminal culpability. They simply are not an appropriate object of those kinds of judgments. Now, obviously, legal insanity is a much trickier category than childhood because we can't just draw an artificial line under a particular age group, right? We have to think about what the relevant capacities are in these cases and when they might be absent. Are they cognitive capacities, moral capacities, volitional capacities, etc.? So one way you could do it is to identify a specific class of mental disorder or mental illness and just take that as an exclusionary category, an exemption category in the manner of childhood, which is perhaps a little crude, but it is done in some places. So in Norway, Norway applies what is referred to as a medical model. And what that means is that all they ask is whether the defendant was psychotic at the time of the relevant act. Were they experiencing psychosis at the time of the relevant act? And if they were, there's no culpability. It doesn't matter what particular impact the psychosis had. It doesn't even matter whether there was a causal link between the act and the psychosis. So essentially what's happening here, I think, is that Norway is treating psychosis as a kind of status effect, right? So when it's operating, culpable action is simply not possible. To the point, we don't have to make a causal link. If you're saying someone under 10 isn't culpable, you don't say, well, is there a causal link between their being under 10 and their acting? No, you just say they're under 10, right? So they're treating psychosis as a similar kind of exempting condition in that way. But I suppose, one of the criticisms that you might make of this kind of account is that it's a little bit oversimplistic. So Linda Grønning, who runs a research project on insanity in Norway, she argues that it really has to be about specific incapacities, right? It can't just be the presence of a particular medical category, which affects different people who experience it in different ways. You have to actually think about which capacities do you think are relevant, right? And whether they apply in a particular case. So one thing that, another kind of approach that people have taken in the law where they've applied a kind of capacity model is to try and reframe the McNaughton rules in terms of a kind of capacity test. So we're going back to McNaughton now, and hopefully you'll remember it a little bit. So instead of asking questions about what the defendant knew, so if you remember McNaughton, it's you have to have either not known what you were doing or not known that it was wrong because of a mental condition. So one thing you could do is instead of asking what they just knew or didn't know, with the absence of knowledge treated as important, we ask whether they had the capacity to know or capacity to understand those things. And sometimes also we add on the prong about having the capacity to control one's actions. So one model of insanity that's applied the kind of McNaughton rules or something similar to the McNaughton rules in this way is the ALI model penal code. So this is the American Legal Institute's model penal code. And what that means is it's not a test that applies strictly in any particular jurisdiction in the USA. Essentially, they are presenting, like, this is what we think states should adopt. Like, this is kind of suggestions, right? You might take this on board. It's kind of a framework presented that they hope states will use. But it's not binding law anywhere. And some states have adopted it to a certain lesser degree at different times, although it's not very popular now. Largely because, as I said here, there was a controversial acquittal in the 80s of John Hinckley on grounds of insanity. I don't know if you know this case. It's the one where John Hinckley tried to assassinate Ronald Reagan in order to impress Jodie Foster. Have you heard of this one? Yeah. So that the ALI model penal code was quite popular up until then. And then there was a big kind of backlash saying, oh, everyone's getting off on insanity, you know, it's too lenient. And then most states reverted to standard McNaughton without the control limit. Some actually got rid of insanity altogether as a result of that. Anyway, I digress. So the ALI model penal code is kind of McNaughton-ish, but instead of asking about knowledge, it asks about substantial capacity. A defendant will not be responsible if they lack the substantial capacity to either appreciate the criminality of their conduct or to conform their actions to the law. So looking for capacity, not knowledge. There are also several jurisdictions in Australia that apply a version of McNaughton that is very similar to this. I think Queensland asks for, it applies insanity on the basis of a lack of capacity to understand what they're doing, lack of capacity to control their actions, or lack of capacity to know that they ought or ought not to do or make the action. So yeah, there are a number of jurisdictions around the world that apply a kind of capacity-fied version of McNaughton, essentially. And a lot of proposals that of reforming the law in this country also focus on turning it into essentially a capacity test. So in 2013, there was a big push by the the Law Commission, which is our kind of law reform body. They published a discussion paper which basically set out proposals for reforming insanity. It didn't go anywhere, but they set it out, and their suggestion was basically turning it into this kind of thing, a capacity test. Okay, so moving away from legal doctrine here and towards more kind of theoretical analysis, it's really common in the literature to see theorists appealing to some kind of irrationality or lack of rational capacity as the key to legal insanity as a concept. So a legal theorist called Michael Moore is a famous proponent of this kind of model. He thinks that if someone is going to count as a moral agent, basically they have to be able to meet a threshold of competency with regard to practical reasoning. Practical reasoning is the process of reasoning by which we move from sets of beliefs and desires to action. So an example of practical reasoning would be something like, okay, premise 1, desire, I want to be warmer. Premise 2, belief, if I put on this jumper, I will be warmer. Conclusion, I will put on this jumper, intent to action, right? So it's moving from your belief desire sets to action or intent to action. And so Moore's idea is that in many cases of mental illness or mental disorder, the required kind of threshold for practical reasoning is not met, though this can in practice be for different reasons. Some people may just not have any kind of coherency between premise and conclusions, but some may be because the kind of internal reasoning process looks like the conclusion follows from the premises, but one of the premises is irrational. And that, for Moore, kind of makes the whole thing irrational. So in Mrs. X's case, that would be the analysis that he would apply. One of the, there's kind of an internal logic to her reasoning, certainly, but one of the relevant beliefs, specifically that the child is being abused, is so irrational that on Moore's analysis, the whole process breaks down and becomes irrational. So he would say that for that reason, she lacks the kind of baseline threshold ability for practical reasoning, in this instance at least, that marks her out as someone who can be subject to moral judgment. And there are other ways that we could frame this rational capacity idea. So one could, for example, specify something like reasons responsiveness, the ability to grasp the reasons for and against acting and to weigh those reasons up against each other. So we might say, well, look, Mrs. X lacks this capacity because one of her beliefs is this unshiftable, indefeasible delusion that she can't test or measure against reality. She can't, it won't shift no matter what evidence she's presented with. And this prevents her from being genuinely responsive to reasons, to the actual reasons for or against acting. And that marks her out as someone who lacks rational capacity. However we just define the necessary capacity, though, the basic idea is that in its absence, someone like Miss X is not someone about whom it makes sense to make moral statements or apply moral judgments, any more than it makes sense to apply them to a very small child. So this kind of analysis is very popular. Some proponents are more explicit than others about drawing parallels to children. Some even draw parallels to animals. I think it strikes people as intuitive to say that at least at the time, Mrs. X or whoever wasn't someone about whom moral judgments really can fairly be made. But there are some real problems with this kind of approach, and I kind of wanted to talk about some of them today. So I think to begin with, you have to think about the ethical implications of thinking about and treating defendants like Miss X this way. Because I would argue that there is a dignity in being treated and regarded as someone who acts for reasons, who has beliefs, who has values, who has desires and aims that are reflected in their actions, even when your thoughts may be in many respects confused. And when we look at Mrs. X's case, I mean, yes, there's confusion there, certainly, but that's not the only thing that's there, right, is it? There's also her desire to protect a child, right? There's her selflessness in putting herself at risk to prevent harm from coming to that child. I think we might want to say that Mrs. X's compassion matters as much as her confusion here. And that to recognize that about her is, in a sense, to meet her as a full human person. Say, you're not just someone who is so deeply confused that we can't understand you or apply any of our kind of analysis to you. You're a person who acts for reasons and who is acting from compassion and from some motivations that are commendable, but you also are suffering from confusion that we have to take into account. A concept that sometimes gets thrown around with these kinds of rationality accounts is the idea of a moral community. The idea being that someone like a very young child who lacks rational capacity is not part of the community of moral agents who make judgments about each other and who attribute praise and blame to each other. And I think this idea of exclusion from a moral community on grounds of rational incapacity in some ways gets at the heart of the ethical issue here. Because what we're kind of saying is, well, there's us over here who are rational actors and moral agents, and when we act, our actions can be assessed and analyzed and judged in terms of beliefs and desires and values and processes of reasoning. And then there's you, Mrs. X, over there, for whom those questions just don't apply, right? And all we need to know about you is whether you were sick enough that your actions don't morally count anymore. And on the one hand, this determination that your actions don't morally count turns out well for you because we're not going to judge you or punish you or find you criminally culpable. But in a sense, I think there's an argument that it comes at the cost of your status as a person in the fullest sense. And this kind of criticism underpins objections that are often raised by disability theorists and disability activists in the context of the civil law regarding the concept of mental capacity. So a lot of people working in that field will see mental capacity as something that, as a concept, is objectionable. The idea of it being something that certain people can just lack, right? It's used in the civil context in the context of medical, financial, and even sexual decision-making. And the criticism is that even when it's implied with the best of intentions out of protection, there's something that's just inevitably dehumanizing about it. So that is, I would say, a major ethical critique of what might otherwise seem to be a plausible account. And I think that the ethical critique is a very persuasive one personally. You may disagree. But even leaving aside the ethical objection, I would say it's not altogether clear the capacity analysis works very well. Because you might say, well, okay, look, it's not a very nice thing to say about Mrs. X, but it is true. Well, I don't know. I don't know that it is true. I don't think that it works all that well. Because the thing about capacity is that it's kind of all or nothing, right? It's kind of a blunt instrument, right? You have capacity or you don't have capacity. And that doesn't always allow us to account for the nuances of a case and to make the kinds of distinctions that we might want to make. So firstly, there's a question as to where this kind of capacity analysis is going to leave someone who can apply what are generally coherent processes of means-end reasoning to irrationally held premises. So again, someone like Mrs. X, who is following a perfectly coherent process of reasoning, but one of the beliefs in it is completely irrational. So given the belief that the child is being abused, the fact that she wants to, she thinks the child is being abused, I don't want the child to come to harm, the child will come to harm if I don't remove it from the house, therefore I'm going to remove it from the house. This is a coherent process of reasoning, but one of the beliefs is irrational, right? So where does this leave her? Does she lack rational capacity? Well, as I say, Michael Moore would say yes. He says the irrationality of that premise basically invalidates the whole process of reasoning and makes it irrational. Not everyone would find that persuasive. Someone might say, well, look, Mrs. X is clearly following a rational process that in some respects makes sense. She's not acting like an infant acts. She's acting coherently in light of the beliefs and desires that she has. So Mrs. X, again, may be a case where it's not so easy to make the case that rational capacity is lacking. And yet I think she is a strong example of someone who we might not want to regard as being fully culpable. And even if we could make the case that Mrs. X lacks rational capacity, I'm not sure that would be a really satisfactory explanation for why we think she's non-culpable. I'm not sure that would capture every aspect of the kind of intuitive non-culpability of her. Because I think we have to come back to the idea that while Mrs. X might be getting some things really wrong here, she's also getting things right. She cares about the things she's supposed to care about, right? She's even taken steps to get the authorities involved before she escalated, right? It seems as though if she had been correct, we might actually praise her for stepping in when the authorities had failed to acknowledge a problem, right? The capacity model can't really account for any of this because on a capacity model, she's just kicked out of the kind of moral community, right? She's kicked out of the class of people who can be culpable. Her case is no different from someone who acted with no reason at all, or who may have acted with malignant motives. Like, for example, let's contrast her with Mr. Y, who suffers from a delusional belief that the baby is biologically his, and so he steals it, right? Okay, so we might feel that there's something different about these cases. Both people are motivated by a delusional belief, but in Mrs. X's case, there's a lot also going right in terms of how she relates to other people, whereas in Mr. Y's case, maybe not so much. A capacity model cannot make any kind of distinction between these two, as long as their kind of delusional belief is equally delusional in each case. But I think that, well, I would argue that it's important that Mrs. X did the best she could under the circumstances that she perceived them to be, given the broader limitations that she was suffering under. So I wonder if there's a way to kind of capture that while still taking into account the whole effect of her illness on her actions, rather than just essentially treating her as someone with just a mistaken belief. Okay, so I want to kind of shift in thinking now, because I think the previous accounts we've looked at have mostly been thinking about agency and arguing that there's a sense in which Miss X's actions were not attributable to her as a moral agent, whether that's because her actions weren't really free, or they weren't, in a sense, really her actions, or because at the time at which she carried them out, she was not a moral agent because she lacked the basic capacities to be one. So I kind of want to move away from this line of thought and towards an alternative line of thought by which Miss X is permitted to have acted with agency, but in a way that does not attract culpability or full culpability. So in these counts, essentially what I want to say is the non-culpability is not so much a matter of an act of agency, but it's a matter of an assessment of her quality of will. It's a term that's used by philosopher Strawson. I'm kind of just applying it to my own ends here. Okay, so the first idea I want to do that's moving into these kind of quality of will analyses is the idea of doing the right thing. So I've got two kind of versions here. Miss X is not culpable because she thought she was doing the right thing under the circumstances as she perceived them to be. And there's a subjective version and a kind of counterfactual version. Subjective version is that she's not culpable because she thinks she's doing the right thing. Counterfactual version is that she's not culpable because she is doing the right thing, given the circumstances she perceived them to be. In other words, if she was correct about her belief, she would be doing the right thing. Right. So she believed the child's in danger. In her mind, she's exhausted all less extreme options, and she's taken steps to protect the child from harm. Given the facts if she's perceived them, we might ask, what else would we have her do? And this, I think, feels like a more natural read of the condition that's set out in the McNaughton rules that we've seen, that she did not know what she was doing was wrong. So the McNaughton rules, because of a defective reason caused by a disease of the mind, the defendant must have not known what they were doing, or not known that what they were doing was wrong. This feels more like the second condition, not knowing what they were doing was wrong, is supposed to be getting at, right? That she thought she was doing the right thing. And this is how some jurisdictions that apply McNaughton tests have used them. So Australia applies it in this way in the case of R.V. Porter, which was, I think, a federal case in Australia. They developed this Porter gloss, which basically says that what we mean by wrong, for the purposes of McNaughton, is morally wrong according to the standards of ordinary reasonable people. So according to ordinary societal standards, essentially. And so if Mrs. X was committing her act in Australia rather than the UK, she might be doing a bit better, because she might be able to argue, well, look, I thought that what I was doing was right. According to the ordinary standards of reasonable people, I did not think I was doing something wrong. Okay, we might want to, and so as I say, there's this distinction between the subjective version and the counterfactual version. The subjective version says the important thing is that she believes she's doing something right, or rather, to be more specific, she doesn't believe she's doing something wrong. But this may be too broad, arguably. So a kind of good counterexample to this, or a worry that people have about this, is the example of Peter Sutcliffe, who was the Yorkshire Ripper. He murdered a lot of women. And his belief was that he was following instructions from God. So he did not believe that he was doing something wrong. He thought he was doing the right thing. I think, at the very least, he's less easily or intuitively exculpable than Mrs. X. Like, we might want to say there's a difference between the two of them. So, you know, it's not to say there isn't an argument for a model of insanity that does include Sutcliffe's, right? But I think he's a harder sell than Mrs. X, right? And it seems like at the very least there's a difference between them, even if we think they're both exculpable in the end. It may not be for the same reasons. So what is this difference? And this is where the counterfactual idea comes in, because I think the difference is that while Mrs. X and Mr. Sutcliffe might both believe they're doing the right thing, what makes Mrs. X sympathetic is that if her beliefs were accurate, we might agree with her, right? Which can't be said for Sutcliffe. So if we want to capture this kind of special feature of Mrs. X and exclude Sutcliffe, we might want to think about framing the relevant question in terms of these kind of counterfactual tests. Right. So there are different ways you could frame this. One is in terms of moral beliefs. So Mrs. X did what she thought was right, and were her beliefs accurate, we, that is society, would agree with her. Or you could frame it in kind of strictly legal senses, which is if Mrs. X's beliefs were accurate, she would have a legal defense. Like, there would actually be a defense that would apply to her if her beliefs were in fact accurate. So this is potentially a fruitful line or way of analyzing or framing insanity. And in fact, the the kind of legal version of this, so this kind of counterfactual, would she have had a defense if her delusional beliefs were true, was proposed in the initial McNaughton judgment, although it was never subsequently applied that way in the courts. Interestingly, though, a counterfactual analysis has applied in Queensland, Australia, which, in addition to the kind of standard McNaughton type provision regarding knowledge of nature and quality and wrongness, also provides this, that a person whose mind at the time of a person's doing or omitting to do an act is affected by delusions or some specific matters, but who is not otherwise entitled to the benefit of subsection 1, sorry, this is, is criminally responsible, this is the important part, for the act or omission to the same extent as if the real state of things had been such as the person was induced by the delusions to believe to exist. So you're culpable if, granting your delusions, you would be culpable, basically, legally speaking. There are some difficulties with this kind of analysis, though, I think, and particularly maybe the second one where we're looking at the kind of legal counterfactual. Because it allows us to factor in the effect of a defendant's mental illness with respect to a delusional belief, granting it as true, but it doesn't really allow us to take into account the effect that the condition might have on a defendant's subsequent response to that belief. So essentially, we have to treat someone like Mrs. X as if she just had a wrong belief, and everything else was fine with regard to her reasoning, her judgment, and so on. But that's not necessarily going to be the reality. If we go back to the kind of scenario I set out, she calls social services, she calls the police, they investigate, they find nothing wrong. She doesn't accept that. In fact, she starts to think that they may be in on it because her belief is so indefeasible and so kind of stuck, I suppose. It's not just that she has a false belief, she has an indefeasible false belief that will not shift in response to evidence or new information the way a regular mistake might be expected to do. Because legally, we wouldn't usually grant a legal defense to someone who falsely thought their neighbors were abusing their child, who had no reasonable or legitimate grounds for thinking that, besides basically a hunch, who refused to accept evidence to the contrary, and who ultimately broke into the house and took the child. I'm not even sure we'd think of this person as having a moral defense, however well-intentioned they might have thought themselves to be. But when we introduce the fact that the person is experiencing psychosis, and that is why they not only held this belief, but were unable to accept evidence to counter it, then maybe our intuitions start to shift about moral and legal culpability. So it's not just about the false belief, it's about the whole picture, the whole impact of the condition. And this, I think, is what leads people back to the capacity analysis, right? This is why we try and apply this kind of read, and then we say, okay, that's all very well, but you're acting as if it's just a false belief. It's not just a false belief, there's more going wrong. The best way to account for that is to say that there's some kind of rational incapacity, right? This is the kind of move. So what I want to do is avoid that move, because as I said, I don't like capacity models, and I don't want to go back to them, but I do appreciate the challenge here. So what I need to do is to suggest accounts or models of culpability in these kinds of cases that will allow us to exculpate someone like Miss X, while both recognizing the full effect of her condition on different aspects of her decision-making process, not just the belief, but that also affords her agency as a moral and legal person whose conduct merits analysis in terms of her values, her beliefs, her desires, and her reasons for action. So how do we do that? Okay, well, I have two proposals that I'm going to finish with. Hopefully I'm not too far over. The first is to appeal to the idea of sufficient concern. So this borrows from an idea of a legal theorist called Larry Alexander that's become reasonably widespread among criminal legal theorists. And the very broad idea is that criminal culpability for an act is warranted only where that act manifests insufficient concern for others, their rights and their well-being, essentially. So on this kind of read, Mrs. X does not attract culpability because her act does not manifest insufficient concern for any of the people involved. She is motivated, we might say, by entirely appropriate and even laudable concern for the child. And arguably, she's not indifferent to the parent. She does try to take reasonable steps first and only resorts to abduction when that doesn't work. The fact that her belief is false doesn't diminish her excuse here either, because it's non-culpably false. It's false for reasons that don't reflect insufficient concern. Contrast, for example, a version, another Mrs. Y, who thinks her neighbors are neglectful because due to racist beliefs rather than disorders or psychotic ones. Her beliefs reflect a kind of insufficient concern for others. Mrs. X's don't. She's not culpable for having this belief. It's not due to any prejudice or anything like that. She's just suffering from a delusion. And this also happily distinguishes her from Sutcliffe. So I kind of like this idea. I think the notion that Mrs. X's act reflects appropriate concern for others seems to be arguably a key part of the picture as to why most people, I think, would want to give her some kind of defense. And so maybe we want to frame our kind of insanity model or insanity understanding in those terms. Okay, the second idea I want to introduce is the idea of reasonable expectations. And this, I want to think kind of back to the causation argument we made right at the start. And one of the suggestions I made at that time was that, well, Mrs. X wasn't culpable because she could not have done otherwise. And we kind of dismissed that, but I do think there's something intuitive about it, right? She thinks this child's life is in danger. She thinks no one else will help. We might be inclined to ask something like, well, what else could she have done, given that? What else was she supposed to do? The problem with the causation analysis that we looked at is that it kind of ended up framing it in terms of compulsion. She literally had no choice. She was railroaded in that direction, which didn't quite seem to be right. I think rather the intuitive feeling may be that she had no choice in maybe a more colloquial sense, as in she had other choices, but they wouldn't have appeared to her to be good ones, right? So what we might want to say instead is something like, there was nothing else she could reasonably have done. Or, as I'm kind of trying to get at here, there was nothing else she could reasonably have been expected to do. So my final suggestion for an analysis of Miss X's non-culpability is to kind of lean into this idea. And so here I'm borrowing ideas from legal theorists like John Gardner, Anak Sarch, and also Lord Hoffman, who in a case called Smith-Morgan in 2000 gestured at this notion too. And so the way I would frame it more specifically is to say something like, if we're going to regard a person as being criminally culpable for their actions, we have to identify or be able to identify some course of action that we would rather they had taken instead, right? Like if you can't think of what would you have had this person do instead, it doesn't make a lot of sense to hold them culpable for what they in fact did do. And crucially, I think this alternative course of action has to be something we could reasonably expect of them. That is to say, we could reasonably or fairly demand. When I say expect, I don't mean in terms of prediction, I mean in terms of making a demand on someone, like I expect you to do this. Something that we could reasonably or justly expect, demand of the person under the circumstances. And so I think this might be a way to get at the sorts of questions that we wanted to ask before, which is that what was she supposed to do? What would you have had her do? In her situation, what would anyone have done? And when we're determining the answer to that question, we can take into account the effect of her mental condition, right? The delusions she was experiencing, the effect that her psychosis might have had on her ability to recognize irrational beliefs as irrational and identify alternative courses of action. And once we factored all that in, we might find that on the facts, she didn't fall short of any expectations or demands of conduct that could reasonably be placed upon her. Okay, so I think if we contrast this with the insufficient concern model, because I think they're both plausible, I think it can still catch cases that we want to exclude on the insufficient concern model, because, it can catch all the cases that would be caught by insufficient concern rather, because in the vast majority of cases, I'd say maybe all cases, sufficient concern for other people is something it is reasonable to expect. If someone is acting with insufficient concern, then on the reasonable expectations model, they're also likely to come out culpable, because you can always reasonably expect, or almost always at least, that someone acts with a sufficient concern for other people. But if we think that there are cases where it may not be reasonable to expect sufficient concern, if we want to make that argument, say, due to, I don't know, maybe the effect of some mental conditions or extremes of pain or emotion, it could also accommodate those cases, right? So it could account for that. If you think that there may be a small subset of cases where sufficient concern is not reasonable to expect, this analysis can take those into account. And it can also potentially accommodate cases where a person may fall short of other kinds of expectations, for example, of basic competency, even when concern was perhaps present. So, I mean, this may be more of an issue if you're expanding it outside of the mental health into a general kind of principle of culpability. But there's a case called Adam Mako where basically this guy, he was an anaesthetist, and he was, anesthetizing a patient, and the oxygen, I think, so I'm not a medical person, but the oxygen thing came disconnected basically, and the person wasn't getting oxygen and they were dying, and he was doing everything he could to figure out what had happened, except for the first thing that he should have checked, which is that the oxygen had come disconnected. In the end, the person died, and he was found to be guilty of, I think, manslaughter, or I'm not sure exactly what the charge was, but anyway, he wasn't exculpated, and the idea was that he should have known to check this. But a case like that, I mean, so depending on how you wanted it to come out, if you think that it's right that he should be regarded as culpable, then the insufficient concern model isn't really going to help you, because he was clearly concerned, right? Like he was clearly acting with sufficient concern for the patient. What he wasn't acting with was sufficient competency. So if you think that that can be grounds for non-culpability, then that's another reason that you might prefer this model than the insufficient concern one. Okay, anyway, those are two analyses. And so just to finish, I want to reiterate or draw attention to the distinction between different kinds of accounts that we've been looking at. So on the one hand, we've got accounts which to kind of different degrees deny agency, which is either because the act wasn't free or in a sense wasn't attributable to the real Mrs. X, or because Mrs. X simply lacks the capacities necessary to be an agent. But on the other, I've tried to present some accounts that I think allow us to afford Mrs. X some agency while still allowing for exculpation. And I think, as I said, the advantage of these sorts of accounts is that they allow us to acknowledge the impact that her condition has on her thinking, her reasoning, her acting, and so on, while still kind of meeting her as a person with beliefs, values, desires, ends, someone who cares about things, who cares about people, and who acts for reasons. So to return to a point I made earlier on, it allows us to essentially construct a kind of moral or culpability narrative in which Mrs. X's compassion is as important as her confusion. And that, I guess, in a nutshell, is why I tend to prefer these kinds of accounts and why my research now tends to focus on developing these kinds of analysis. And I've presented a couple that I've been thinking about. Okay, so that's it. Thank you very much.
Hi, Claire. Very interesting presentation, covers a lot of ground. I'm a little bit, I just have a bit question about the reasonable expectation model that you seem to be pushing near the end, and the example you gave at the end about the doctor who tried to do everything he could to save the patient based on the oxygen coming undone. I guess my worry with the reasonable expectation model was that it kind of kicks the can down the road, as it were. And your example of the oxygen deprivation patient kind of shows the problem in that you say that it kind of depends on how you want it to come out, right? So it seems as though what we'd hope for in these tests is a test that would help us to arbitrate between situations in which we think that the defendant is culpable and situations in which the defendant isn't culpable. But in this case, it's all about how we're going to assess what counts as a reasonable expectation. And so the very example that you use shows that it's not doing the work that we need it to do, which is it's not helping us to decide whether or not that person is culpable or not, precisely because we have to first decide what counts as a reasonable expectation. And so all the work is going to go into trying to figure out which expectations are reasonable, which ones are not reasonable. And I'm wondering how we're going to flesh that out. And once we start fleshing that out, maybe we're kind of back to square one, so to speak.
Yeah, that's a good objection. I mean, it's one that's been made to me before. I think, okay, so it depends on how I kind of framed this in the context of maybe we could frame an insanity defense like that. I think that's maybe a kind of simplistic version of what I think is going on that I've not, just for the sake of trying to make things a bit simpler. But really what I think is that what we want to do is to reframe certain culpability tests that we apply within the criminal law in terms of reasonable expectations instead of models that we apply right now that appeal to reasonableness. So for example, in the context of self-defense, so you can have a defense of self-defense if you honestly believed that your life was in danger. I mean, I'm being loose with the specifics of how it's set out, but you honestly believed in the threat and you responded to the threat with reasonable force. And so in the legal context, we've sometimes had cases where someone who suffered from a delusion of a threat, there's a question as to whether they can plead self-defense, because if you just have to have an honest belief, then a delusional belief will meet that criteria. It might seem like I've gone way off topic, but I promise it's going to come back around. But where the difficulty has been in these cases is with the reasonable force requirement, because one of the kind of strong idea that's come out is that for someone with a delusional belief, it doesn't make sense to apply a kind of reasonableness test because they're always just going to come out as behaving unreasonably, right? Because they are seen as inherently unreasonable. And so where this kind of reasonable expectations idea for me initially came out was trying to reframe those kinds of tests, those kinds of objective reasonableness standards that we apply all the time in the criminal law. So one thing I would say just, is that we ask, in the criminal context, it may be very unsatisfactory for philosophers, but in the criminal context, we ask juries to make very loose determinations about whether someone was reasonable all the time. And we don't give them very clear definitions as to what it means. So from that perspective alone, reasonable expectations isn't really doing anything that we don't already do. But what I would say is that my idea for it was that it would be put in specific context. So you would be like, did this person fall short of reasonable expectations of force used? Or reasonable expectations of belief? And I think that within the framing of different culpability tests and different defenses and different offenses within the law, you could potentially put quite a lot of content into what a reasonable expectation would require in that context when you're setting out what that kind of culpability test is. Now, I think certainly as I've presented it here as just an analysis of why a person with mental illness might not be culpable, you're absolutely right, it's way too vague. But as a model that we can use to kind of change culpability assessments within the law, there is scope to put quite a lot of content in there. And to see different things as being reasonable expectations with respect to different defenses and offenses and so on and so forth. I don't know if that helps or answers your question.
I was just wondering what happens once someone is declared inculpable in the UK. I ask, coming from an Australian background where people who lack capacity can be held at the governor's pleasure, leading to indefinite hospital orders or indefinite imprisonment. What's the situation in the United Kingdom, and how do you view the ethical obligation of lawyers who are presenting clients who may lack capacity and considering the potential harm that could be caused when you go down that route?
Yeah, that's a great question. So it's basically the same. So when you, if you successfully plead McNaughton, so you will get an NGRI, a not guilty by reason of insanity, which is in some respects a qualified acquittal because, as you say, it doesn't, usually if you're acquitted, you're acquitted. The court has no power over you, right? This kind of acquittal, they still do. There are certain specific hospitalization orders they can make, not only hospitalization orders, so there's a hospitalization order. They can add what's a Section 41 restriction, which basically, as you say, means essentially indefinite detention. If they're to be let out, it has to be with the say-so of the Secretary of State for Justice. So really, what it does is it kind of turns that hospitalization into a criminal justice matter rather than a medical matter, straightforwardly. There are other options too. They can make a supervision order for supervision in the community, or they can choose to just let you go. But if you succeed on pleading insanity, you're not free in the sense that you are if you succeed on pleading, say, self-defense. You're still under court powers. They still can decide whether they're going to let you go or not. And yes, so the question about, and that's the same too, sorry, if someone is found unfit to plead, which is when it's not so much about the culpability question with respect to them performing the act, but rather about whether they are felt to be someone who can participate in the criminal justice process. If they're not, then the courts will establish whether they think they committed the actus reus, so whether they did the basic thing, but not look at kind of mens rea, whether they had the relevant intent or whether a defense applied. They don't look at that because that involves them, that requires them to take part in the criminal justice process, which we think they can't do. So again, these kind of hospitalization orders, restriction orders come in over someone in respect of whom culpability hasn't really been assessed. So there are huge ethical problems here. I mean, and I think in terms of whether you raise it, yeah, I mean, well, so a researcher called Ronnie Mackay has been doing, I think he's the only person pretty much who does empirical research on insanity defenses in this country. And his finding is that they are very, very, very rarely used. And we don't really know why. I mean, I think it's at least plausible to assume that some people do not want to raise them because, you know, unless you're looking at really long-term prison sentence, you might, as you say, be worse off getting an insanity defense if you end up hospitalized indefinitely. In fact, prior to 1991, if you got an NGRI, they had to apply the Section 41 restriction. So it was an automatic indefinite detention if you were found not guilty by reason of insanity, regardless of, you know, whether they actually thought you posed any kind of risk or there were some people who sorry, this is getting off topic slightly. There were some people who had done things while suffering from hypoglycemia due to diabetes or while in an epileptic state, who ended up under Section 41s. And some of those people actually went back and said, I'd rather just plead guilty and get a conviction because I don't want to be hospitalized. So yeah, I mean, this is a huge debate around this. And this is one of the reasons that I like trying to, I mean, so to put it in more of again, sort of focus on the theory, but to put it in a kind of criminal law context, one of my kind of major problems is that there's this problem about relying on these insanity defenses that then lead to these restrictive rules. And I'm trying to think about, are there ways in which we can take a person's mental condition into account through just the general culpability rules that we apply to everybody without sort of shifting people over to a separate insanity defense? And one of the ways I'm trying to do that is, as I said before, by reframing reasonableness standards that we apply a lot in the law in terms of reasonable expectations, which are a little bit more flexible with respect to the impact of a mental condition. Anyway, sorry. So yeah, big ethical issues, as you say.
Thank you for your interesting presentation. I just wondered, you mentioned that, for example, one of the factors that can actually be taken as to free somebody from the culpability is irrational position or irrational factor in a chain of thinking. Now, how do you define irrational? Is it just something that doesn't fall into the category of what is the common belief?
Yeah, so how to define what counts as an irrational thought, or irrational to the degree that it removes culpability, is a really big question. I mean, a couple of things. So one idea is to appeal to something like reason's responsiveness. So it's not just that in Mrs. X's case, it's not just that she has a false belief. Lots of people have false beliefs. Lots of people have irrational beliefs. But to appeal to something like the kind of indefeasibility of it, the fact that she can't weigh it against reality, she can't really test reality in the way, like if I suppose, if I had a suspicion, maybe an irrational suspicion that my neighbor was abusing the baby, and then plenty of evidence came to the contrary, I would probably shift my thought, or at least be able to. And if I didn't, then maybe I'd be culpable for that because I'm suffering from other biases. But I think the idea would be that someone like Mrs. X can't do that. Now, is that right? Is that true? I don't know. I think that we do, in discussing these kind of cases, sometimes come down a division, and you certainly see this in the literature. I certainly see it in Michael Moore's writing, for example, that there's the very rational, very, everything perfectly in order on the one side, and then you've got on the other side people like Mrs. X, for whom, who are not thinking rationally the way that the rest of us do. I don't know that it's so straightforward, right? I think we're all very irrational at different times. When that irrationality becomes relevant to culpability, and whether it has to be connected to mental illness, and why that matters specifically, why that cause of irrational thinking is more non-culpable than any other kind of irrational thinking, is one of the big questions that we're trying to deal with. And I'm not sure there's a clear answer.
Thanks for the interesting talk. Actually, my question is actually what you're bringing up just now. So I'm a psychotherapist, and I'm struck by the premise that is kind of implicit in everything that you've presented, which seems to be, when I listen, something like the fact that, yes, there are two groups of people, some people who are, in inverted commas, mad or ill, and other people who are, in inverted commas, normal. So I'm curious about whether that's true or not, and you were kind of hinting at the fact that it might not be true. Are we all on a spectrum? So that's the first part of the question. And then the second part, which is related, is we're kind of assuming that. So I'll take it the other way around. If someone commits a crime, a murder or anything extreme, how could we argue that they could have done otherwise? Even if they don't have a diagnosis of psychosis, there's something in them that is, from the perspective of a psychotherapist, suffering a lot, or, a psychiatrist might say something else, but there's something so extreme going on if someone commits a murder that would be as explanatory as an illness called psychosis. It might be something else, but there are causes within the person that are so extreme that it pushes them to commit this extreme crime. And those causes need to be looked at, in my opinion, in the same way as what we call psychosis. I don't know if I'm making sense.
No, it makes sense. I think I completely agree with you. Yeah, I mean, I think with respect to the way that we look at kind of insanity in the law, I think one of the problems is that we do seem to treat it sort of like, you're either, and especially if you frame it in terms of capacity, right? Like, you're either someone who is so mentally ill or so confused that your actions are almost that of not a moral agent at all, or it's irrelevant. We don't take it into consideration. And that seems in some ways to be the position in the law. Like, we have this insanity defense. We don't have very clear avenues as to how a mental illness might be factored in as just evidence relevant to whether someone intended to do what they did, whether someone was, deserves a defense on the basis of the fact that they thought they were under a threat, all these other kinds of ways that we assess culpability. We don't have very clear avenues of doing that. We tend to just treat it as, okay, it's a special defense for special people kind of thing. And this I think is extremely objectionable in a lot of ways. And actually, so there's an international treaty called the Convention on the Rights of Persons with Disabilities, a UN treaty. And one of the things that it tries to protect is the right to legal personhood, and also the right to equal access to justice and the recognition before the law. And some interpretations of that have said that insanity defenses are just not permitted because they don't recognize you as an equal person before the law, subject to the same tests and, you know, factoring in the impact of your mental disorder, yes, as evidence, but not as something that separates you out as a special category of person, right? And so there's a very strong feeling among some groups that that's what insanity defenses do. I'm not sure that they do. I mean, I think the capacity models do. I think the current model we have is not a capacity model, and it just isn't a very good test, but I don't think that it's a capacity test. But I do think, you know, this kind of concern is largely, or partly at least, what's motivating my research here, to try and figure out ways in which we can, look, Mrs. X is not a separate type of person who we just can't ask these questions about, right? She's someone who believed certain things, thought certain things were happening. We can take into account the impact that her condition has, but we can still answer these questions. And if we can figure out, I mean, one of the things I think, if we can figure out, I mean, obviously the reasonable expectations model does need work, and if you can figure out some kind of culpability model like that in her case, where we look at, you know, what is it reasonable to expect of her under X conditions, then maybe that can expand out to other people too. Like maybe that's a model that we can apply to all kinds of people, and we can perhaps have a better way of assessing culpability than we do now. That may be more lenient, which you may like or dislike. I tend to like it.
Hello, I just want to say I think it was a brilliant presentation. And I think the example used, the Mrs. X case, is really good, and it lends itself to be manipulated and pushed a little bit further, which is kind of what I would like to question. With the Mrs. X case, and kind of linking it to the counterfactual version of doing the right thing, if, say, in the case, instead of just taking the baby and keeping it safe in a hostel or hotel or her home, what if perhaps Mrs. X, say, attacked the parents, and under the counterfactual version, in the circumstances, she believes she's correct, and say perhaps her psychosis is pushing her to the fact that she believes not only is the baby in harm, but so is she, where would that leave her? Would that mean has no moral agency, or she's she's allowed to do it?
Yeah, I think that's an interesting way to shift the example. I think, I mean, look, I think you'd have to then analyze it in different ways, right? I mean, so, okay, it depends. So we're thinking about moral counterfactuals or legal counterfactuals, firstly. So would she be morally justified? I mean, it makes the case a lot more complicated in terms of the moral justification, right? Because it seems like, well, you know, if you think someone's abusing their child, you may be morally justified in taking steps to remove the child, but you may not be morally justified in taking steps, in attacking them violently. If she thinks that, there's different aspects to the changes you made, so that she thinks that they're threatening her.
Yeah. So she believes...
Okay.
Let me try to explain this.
No, it's okay, it's good. I'm just trying to think it through.
As she goes to get the baby, and the parents come into the room, they see her, and she believes now she's in the immediate danger. And so as a result of that, she attacks the parents.
Yeah, I mean, you could argue, yeah, I suppose. So this comes back to the kind of example I was using before about the self-defense. So where you say, well, if someone delusionally thinks that they're in danger, do they then have a defense in terms of using reasonable force? Yeah, I mean, it complicates it. I think the question is, right, so there'd be two directions you might want to go in. One is to say, look, this is so complicated. She's clearly very confused. Let's go for a capacity analysis that just lets us say, like, we just don't think she's culpable. She's suffering from this severe condition. She can't make judgments very well. She can't assess what's happening. She can't really understand what's happening. And it doesn't make sense to try and kind of get into the weeds of this analysis about what she thinks is happening now and what she thinks is happening at this point and that point. And I think that's very plausible. And I think that's one of the reasons why capacity analysis are so popular. If you wanted to go down my route of trying to really get into it, yeah, it's going to be more difficult. I think you're going to have to get into questions of, okay, well, does she think that the parents are threatening her? Is she acting with sufficient concern, I suppose, for the parties involved? Is she falling short of reasonable expectations of sufficient concern with respect to the parties involved? So the question becomes much more complicated. And this is kind of, unhappily, a good counterexample. And one of the reasons why people take models like mine to just be too complicated. I think it's worth doing that kind of work to figure out like how it might work. But I do think, I mean, there may be some cases where we do think she's culpable, right? Like there may be some cases where, you know, and not every case of non-culpability due to a mental illness is necessarily going to be for the same reason, right? There may be some cases where we do think actually a capacity analysis is the only one that works here. It may come to that. Like, but there also might be, I mean, I think, so the counterexample I kind of came up with was the Mr. Y who thinks that, so I don't know, let's say he thinks that he delusionally believes his wife is cheating on him, so he hits her, right? I mean, I feel like there's a delusion here, but I don't necessarily know that I would want to exculpate him because I think the idea is that you're supposed to, I'm trying to get you to take more into account than just the delusion, but also other aspects that are influencing their behavior. Like cruelty or I don't know, prejudicial beliefs or compassion or the desire to help someone or to not do harm. In terms of this example, I think I would have to think it through to see exactly how it all works out. But it's a good counterpoint. Thank you.
Yeah, I just wondered whether you maybe moved away from the counterfactual version a little quicker than you needed to. I mean, it said that. So I wonder if you altered it just slightly by saying that she's not culpable for believing that things are the way that she thought they were, whether it might not sound more plausible then. Wasn't the problem with it that the belief might be false and so, and she might be culpable for it being false as well?
No, yeah, I think that's true. I mean, I think sometimes it feels like, well, when you're thinking about kind of someone with a very false delusional belief, like what role is the mental illness playing here? And some will take the view that, well, it's playing a very special exculpatory role. And some will take the view, well, no, it's evidence. And what it's evidence for is, one, that she really did believe this thing that otherwise you would never think someone would believe. And two, that, as you say, yeah, she wasn't culpable for believing it. She didn't come to this belief through a lack of care or a lack of investigation or prejudice towards the woman. She came to it through non-culpable means that she can't be blamed for. So yeah, I think that's a good analysis. Yeah, I think I'd still need to delve into the details of that particular case one. But yeah, I think that's really a good point, that the role that her mental illness plays can sometimes be evidence that, yes, she really did think that this was happening, and no, it wasn't her fault that she thought this was happening, and the fact that she thought this was happening is not reflective of some failing in her, the way it would be if I just suddenly decided that my neighbor was abusing their kid and didn't do any follow-ups, and, you know, it was rooted in just prejudice about the kind of person that my neighbor is. You know, then you might say, well, you're culpable for having that belief. But Mrs. X is not, and her disorder is evidence for that.
Thank you for the lecture. My main concern is that we should probably address the problem of consciousness first, properly. So at what point can we safely declare that the individual was indeed delusional and decide to free them of responsibility, or on the contrary, force specific measures on them since we believe there is some correct perception of events and we section them or dictate this perception of events in any way? So in the example that you provided, how do we properly investigate whether the defendant even had a delusional belief in the first place, since all the following reasoning is kind of based on the assumption that she did indeed have the belief? I'm sorry,
So it's just to be clear, so you're asking how do we establish that she genuinely had a delusion? Yeah. Okay, I mean, so in the context of the criminal law, it would be done through psychiatric evidence. She would be, so I think for an insanity defense, for example, you have to be interviewed by 2 psychiatrists, and then they will present a kind of report on you, and they will make the case that, yeah, it seems like she really did have this delusion, or not. But very often in insanity cases, the psychiatrists will agree. Even if one is informed by the, instructed by the prosecution and one is instructed by the defense. They will sometimes just agree in advance, this is probably an insanity case, for example. So it would be, I mean, whether the jury then believes the psychiatric evidence, that's up to the jury. So the jury can decide what they like, really. I mean, they're directed, so in the criminal law, they're directed by the judge. The judge will be directed by the psychiatric evidence. And then the judge will tell the jury, basically, he'll give them kind of directions around how particular legal tests work. So he'll say, if you think this, you should find guilty. If you think this other thing, you should find not guilty. If you think that the person because of a defective reason caused by a disease of the mind, didn't know what she was doing or know what she was wrong, you should find NGRI, not guilty by reason of insanity. And in kind of directing the jury, he will be influenced by what the psychiatric reports have told him. So there's kind of a question as to who determines these things, because in principle, it's the jury, right? The jury are free to decide as they wish regarding the guilt or innocence or insanity of a defendant. But then they are very strongly directed by the judge, and the judge is very strongly influenced by the psychiatric reports. And I think, returning back to Mackay's research, it's very unusual that the jury go against what the psychiatric reports have said. So yeah, I mean, it's kind of up to the jury. They don't have to believe the psychiatrists that, if the psychiatrist says she was delusional and she really did have this delusional belief and she was suffering from psychosis, the jury are likely to believe them. Sorry, I don't know if that was that, did that answer your question? Oh, okay, good.
Thank you so much for the talk. It was really interesting. My question kind of adds a second or maybe third dimension to, instead of just looking at culpability, you know, early on you said that one of the ways that you can think about it is through mitigating factors on sentencing. And I think one of the reasons a lot of us are troubled by a guilty conviction for Mrs. X is because of how harsh the criminal law is. You know, we know it's a blunt instrument. It's going to jail or being sectioned. They're both really difficult things. So I'm interested in hearing from you in the context of criminal legal theory, where your work sits in terms of punishment and what the outcome of finding a conviction of guilt is, in the sense that if we take any of the quality of will accounts, you know, you were saying those get really complicated. What if we think about where someone has pleaded this, how it impacts the aspect of punishment in criminal law?
These are great questions. And to be honest, if you're asking where my research sits, that it kind of doesn't. I'm very interested in like the theory side of things. And I sort of tend to think, I mean, and this may be naive of me, but I kind of I think they should be separate questions. Like the culpability determination is a question of were you guilty or not? Do we regard you as a criminal or not? The question of what happens to you afterwards is, I mean, it's not that it's not connected, but I think, so one of the difficulties with insanity in particular is that sometimes you'll see the rules being twisted. And you see this in particular in the context of what we call legal automatism, which is when you're looking at people who acted without conscious control. So sleepwalking, fugue states, people who acted under hypoglycemic states. So they just weren't present mentally. And strictly speaking, we call this involuntary action. And if someone acts involuntarily, they're entitled to an outright acquittal. However, the law has implemented some kind of rules that say, well, if we think that the reason you acted that way was because of something that meets the McNaughton status test, a defective reason caused by a disease of the mind, you're not acquitted outright. Instead, you're given an insanity defense. That's led to some really bizarre distinctions. And the reason they do it is that they want to hospitalize, right? They want to be able to hospitalize, to at least have that option. So, you know, the questions are connected in practice. I think that it's a mistake to connect them in that way, right? Like these are separate questions. We shouldn't be tweaking our culpability assessments to get the outcomes we want. The outcome is supposed to be a conclusion of the culpability assessment. You don't make that decision first, what do I want to do with this person, and then twiddle around the culpability rules to get the right outcome, right? You know, I think to that degree, I think, you know, just separate them out, because a lot of people say, well, you can't have these kind of lenient insanity offenses, or you can't have someone getting exculpated because of a delusion via self-defense, because then you can't hospitalize them, they're just acquitted. I'm like, well, yeah. I mean, they're not culpable. The power to detain comes from the culpability assessment. If you want to argue that they need to be detained for, you know, civil mental health reasons, that needs to come through a civil mental health mechanism, not through the criminal law if you determine them to be non-culpable. With respect to sentencing, I mean, so this is an interesting question, because a lot of people will say, why worry about this when in fact you can just kick it all to sentencing, right? If someone is felt like Mrs. X, if she was found guilty, probably wouldn't go to jail, right? If she had recovered, she might not even be hospitalized. She might be, because I say up to 91, they had to hospitalize. Now they don't. They can apply an absolute discharge if they had to. So if she, and there's been many cases where someone, you know, has been found legally insane, but they're doing well, they're fine, they don't need to be hospitalized, and so they've been let go. So you could say, well, you know, as long as that's working okay, does it really matter whether she's acquitted through kind of a reasonable expectations or sufficient concern means that get into her quality of will, or whether she's acquitted through a capacity account? Like, who cares? I think it matters because, and again, this may be being naive about the value of the criminal justice system, but I think it matters that people are able to stand up and give an irrational account of themselves and their actions if we can allow them to do so. And the example that I always use is something by John Gardner, who wrote In the Mark of Responsibility, and he talked about how, so he talked about diminished responsibility and how it's a partial defense to murder. Another partial defense to murder is loss of control, where you're basically saying, I lost control of myself under circumstances that really anyone would have. And again, you've killed someone, so it reduces it to voluntary manslaughter. And in terms of how loss of control had been defined, for a while it was defined so that it had to be a sudden and temporary loss of control. And this meant that women who'd been abused for a long time could not plead loss of control. If they snapped and killed their husbands after a while, but it tended to be more of a slow burn thing. Like they would just be pressured for a long, long time, and then one day they'd wake up and be like, I can't take it anymore. That didn't fit within sudden and temporary. So they couldn't plead loss of control, and they had to plead diminished responsibility and essentially say there was something kind of wrong with me to the extent that I was not fully responsible. They didn't like that. And there was a huge push to be able to plead loss of control, to change the law on loss of control, because they wanted to be able to stay, in court in front of a jury of their peers. I lost control in circumstances where it was understandable for me to do so, not I was impaired with respect to my responsibility. That mattered to them. I think it does matter to people to be able to say, this is why I acted, these were my reasons. I'm not someone who is just not even subject to these considerations. This was the story that I want to tell about myself. And these kind of models allow us to do that. So I think for those reasons that even if we can mitigate all of the negative outcomes in terms of subsequent where you go afterwards in terms of sentencing, I think it's still a bad thing if we can't allow people to account for themselves as full human persons within the law. So that's why I think this is important to do. Sorry.
Hello, thank you so much for the talk. I just wanted to ask, it's not directly about your account, it's more about earlier in the presentation. I just wanted to ask about the definition of compulsion, because it seems quite distant from the definition of compulsion that I have. So for example, I have obsessive compulsive disorder, and the definition of compulsion there seemed very much married to this idea of that's the only possible outcome that could have happened. And my more colloquial mental illness definition of compulsion is more surrounding it will cause an immense amount of distress for an individual. However, I'm never a robot that has to fulfill a mechanism.
That's interesting. I also have obsessive compulsive disorder. And actually, that's why I was interested initially in compulsive actions and the relevance of responsibility. And what you say is a really interesting point, because this is what I was thinking too, right? Because a lot of the time when people talk about compulsions, it's like, this is the only thing you can do. And sometimes what they'll say is, it doesn't appear to you as desirable in any way. And I'm sort of like, well, it does, because it alleviates the pain that you feel from not doing it, right? Like you're experiencing this intense anxiety. It's an unpleasant sensation. And the compulsion appears desirable or valuable to me because it alleviates that. So I agree. I mean, I think this is another case where, in my mind, the reasonable expectations analysis works quite well. Because is it possible for me to resist a compulsion? Yes. Is it always reasonable to expect me to? No, right? But sometimes maybe yes, right? Like so the example I used to use is I'm stuck washing my hands. This has happened to me a few times. I'm in the bathroom, I'm stuck washing my hands. I'm late to class because I can't stop washing my hands. Is it reasonable to expect me to, I guess, expend the intense effort that it takes to stop washing my hands in that situation to avoid being 5 minutes late to class? Well, I guess that depends on your views on punctuality, but I would say that there's at least a case that it isn't. But if someone was choking to death behind me, I think then it probably would be, right? So, but again, it's not that we're automatons, but I think that this is another example of where the reasonable expectations type model, or even a sufficient concern model, right? Like, not expending that effort does not necessarily display insufficient concern once you take into account how hard it is for me to stop. If the consequence is just like coming into a talk slightly late, but if someone's gonna die, then I think it probably does. So there are ways, I think, that's a good example of ways in which those analyses actually work a lot better than something like the compulsion analysis, which assumes just non-capacity, right? Like, I mean, I have the capacity. It's just, it's really, really hard, and I want that to be factored in. So, yeah.
Thanks so much. I have many questions, but I'll focus on one. It seems to me that our kind of goal here is to find a reasonable generalization or law that allows us to find Mrs. X not culpable. And I wanted to know if you've kind of come across anyone who is looking to find her culpable, coming at it from the other perspective, and how can you manage your subjectivity around that?
Yeah, I mean, I think, I obviously come to it from the bias of thinking she deserves some defense. But I mean, as I said at the start, I think you could make the case that she is. And as I say, the criminal law in England and Wales probably would find her culpable. So you would say, well, look, she knows what she's doing. She knows that what she's doing is not legal. She doesn't have to do it. She's not compelled to do it. She's chosen to do it. And, as I say, if for someone who just falsely believed that their neighbor was abusing their child, and falsely believed, though not delusionally, that the police were complicit in this due to, I don't know, spending too much time reading conspiracy theories on the internet maybe, we probably wouldn't think that they were excused for breaking into their house and stealing their baby, right? Until you start factoring this in. So I think that there is an argument that, well, maybe she is culpable. And in that situation, I think what you'd want to do is the thing that would make that kind of mitigate that, I guess, the harshness of that would be to look at sentencing and say, well, okay, she's culpable, but is this someone who it's helpful or beneficial to send to jail? Especially given that she maybe now has been treated and is not likely to do this kind of thing again. But yeah, I mean, I think there are ways, certainly, I mean, just look at the M'Naughton rules as they apply in England and Wales. They would find her culpable because she knows what she's doing. She knows that it's illegal. So, yeah, but I guess I do find that really very hard. I mean, I suppose I come back to the idea of, well, what is she meant to do? Like what do you want her to do, right? And is that thing that you want her to do? I mean, I guess what you want her to do is not steal the baby. But once you factor in the fact that she thinks the baby is, going to die, and she doesn't have the ability to measure that, and she doesn't have the ability to realize that that this is an irrational belief. I mean, the only reason that we want her to not do it is because we know from the outside perspective that it is irrational, but she doesn't know that. I don't know. If this was a situation where she turned out to be right and the baby died because she did nothing, we'd probably say, well, why didn't you do something? I don't know. I think it's very hard from my perspective, and maybe there is a bias to think that she's fully culpable for this because she is acting from such concern and compassion and is in some ways doing what we want her to do, which is to be a responsible citizen who cares about the other people around them and, is taking steps to care for other people. And if we're criminalizing her for that, then I don't know. It doesn't seem like we're getting the right answers in terms of our criminal justice system.
Well, unfortunately, we have to bring things to a close there because we're out of time. Many apologies to those of you who had questions and didn't get the chance to ask them, but thanks to those who did for your participation. But thanks above all to Claire for a very stimulating talk.
Thank you.